Good afternoon, everyone, and good morning if you're on the West Coast, and good evening if you happen to be in Europe or Asia. Welcome to the June 2022 TSCA 3030. We have a very interesting topic for you today. It has to do with occupational exposure as it's being handled under the Biden EPA. I think you're fairly aware that the Biden EPA has gotten rid of this whole concept of what we call RegNet, and which means basically, you pay attention to what other agencies are doing with respect to chemicals, like the Consumer Product Safety Commission, and what other EPA offices are doing, like the Clean Air Act office or Solid Waste office, and you pay attention to that, and you incorporate, those regulatory activities in your risk evaluation. Well, that's not what the Biden EPA is doing. Biden EPA is basically saying that people are not complying with the OSHA requirements. They're not complying with the Clean Air Act requirements. They're not complying with CPSC requirements. And they're doing risk evaluations under the assumption that there's a massive incompliance. So I'm Herbert Stryker, and I give a lot of these. Next slide, please. And I'm joined today by my partner, Larry Halpern, Lawrence Halpern. He is a very prominent OSHA TSCA lawyer. He's been doing OSHA work for about 45 years. So it'll be very interesting to get his ideas or sense of how EPA is doing in terms of handling occupational exposure assessments under the Lautenberg revised TSCA. Next slide, please. Okay, so I'm going to turn this over to Larry, and then I will join about midway. Take care.
Thank you, Herb. Good morning, afternoon, and evening, depending on where you are. The first slide asks the question. As you know, EPA has proposed its first rule under TSCA Section 6 for asbestos Part 1, and basically proposed a phased-in ban. For most chemicals, a ban is not likely to be the answer. Asbestos Part 2 is going to address asbestos in many installations of asbestos in the United States as a fire retardant. Clearly, that material can't be banned. It's in place, and it's going to be subject to some sort of continuing ongoing management, maintenance, and operations procedures. So the question is, when you get this kind of scenario, which agency is going to take the lead going forward? Now, Congress and the White House have largely made many of those decisions, but I think the things we'll talk about today should help guide industry in determining its role and approach to these issues. I think most people would say that OSHA has greater expertise in developing and enforcing rules governing workplace safety to toxic chemicals. But as this suggests, this presentation is going to suggest, OSHA lacks the necessary rulemaking authority and budget to effectively address workplace exposure to toxic chemicals. That's been recognized for some time. EPA under Lautenberg has the necessary firepower, rulemaking authority, which it apparently plans to use, already flexes muscles, but it's got less expertise. So while opinions vary, and this one we solely mine, long term, it appears that industry needs to consider the possibility that its industry and workplace safety would be better served by encouraging EPA and OSHA to develop a formal MOU and cooperate together in developing and enforcing rules governing workplace exposure to toxic chemicals. Next slide. To give you an idea of the current situation, this is not my opinion, I'm relaying the information that OSHA has presented. OSHA asserts 50,000 deaths annually estimated are related to chemical exposures. Most of the BLS data deals with the 5,000 per year workplace deaths. I don't mean to in any way minimize that, but if these numbers are right and the 50,000 is clearly an estimate based on a lot of analyses that aren't straightforward, 10 times as many deaths per year are allegedly due to chemical exposures than the typical run over a forklift, caught in a machine, explosion, one of the other things that sometimes unfortunately happens in a workplace environment. So as you can see, if there's really 50,000 deaths annually, most of them are not captured by the OSHA injury and illness record keeping system. And so updating that system is really not going to help make things any clearer. let's say there's 60,000 substances on the TSCA inventory. As far as permissible exposure limits, OSHA has about 425. Most of them were adopted in 1972 based on 1969 consensus standards or federal standards. OSHA has indicated most of them are outdated. In the last 50 years, OSHA has managed to update just 30 of them. And the reason for that is the way the statute has been interpreted by the courts. The burden of proof on OSHA to sustain a standard takes an enormous amount of effort, and the agency simply doesn't have the resources. In addition to pills, there's a respiratory protection standard. And then there's the general duty clause for recognized hazards, which is incredibly resource intensive. It's rarely used. It'd be comparable to conducting a rulemaking through the adjudicatory process. And I imagine industry would have a lot of complaints about that, because if effectively a litigation against one company would be an attempt to set a standard for everybody that would be involved with that chemical. Next slide, please. I also should add that according to the data, only 7% of the chemicals covered by pills, let's put it this way, only 7% of the chemicals with 1 million pounds or more of production or import into the US are covered by pills. So you can see there's a substantial gap between the current regulatory framework and the actual exposures in the workplace. Now, there are other standards that OSHA has besides respirators. There's PPE, but you have to provide that when necessary. So basically, with respirators as PPE, OSHA would have to show that it's necessary to protect the employee. Hazard communication, basically a generic communication and training standard. It is not a regulatory standard. There is a requirement that safety data sheets list the OELs to the extent that an employer adopts or a manufacturer adopts them. Relatively few are listed in safety data sheets, which means either manufacturers aren't complying with the rule or they're just not developing OELs in the first place, which means there's very few being developed and shared. Chemical process safety standard only covers 110 toxic or highly reactive chemicals. So that's certainly not going to be a major way of regulating the chemical environment. The chemical emergency response standards are basically a generic response standard, which says if you have a hazard that's beyond what can be controlled by the people in the workplace, then there's an emergency response team, but it doesn't set any pills. So you've got virtually no OSHA regulation specifying the particular exposure levels that are permitted in the workplace for most of the chemicals that are present. Another problem with the OSHA Act is it doesn't cover sole proprietors of military, and it doesn't cover state and local employees in approximately 22 states without state plans. To the issue that Herb will address and that EPA has brought up and has brought controversy, OSHA and EPA, consistent with, believe the general opinions of most of the industrial hygiene and workplace safety community, believe there's a principle called hierarchy of controls, which means you start with engineering controls as being the most effective, eliminating the chemical, substituting the chemical, and closing the process. Ventilation, when you finish with engineering controls, to the extent they don't provide adequate protection, go to administrative controls or work practices. Those terms are used interchangeably. The OSHA pills standards have an introductory generic section which says you must use feasible engineering or administrative controls to the extent they're feasible to reduce the exposure as low as possible toward the pill, and any gap has to be made up with PPE respirators. But you can't simply say engineering and administrative controls aren't adequate, therefore we're going to skip them all together and just use respirators. And the respirator standard says essentially the same thing. Now, in what might be viewed as an overstatement, OSHA's position stated in 1978 was that respiratory protection is relegated to the bottom of the compliance priority list because it's ineffective, unreliable, and unsafe. Now, I think that's an overstatement, but at the same time, I think it's important to recognize what the agency's concerns are with respect to respiratory protection. The views are generally that it interferes with communication, it interferes with vision, interferes with mobility. There's issues about whether the respirator is going to be fit properly. If you have facial hair, it interferes with the fit. Rapid movements can interfere with the fit. Some people's bone structures may not be suitable for some respiratory protection at all. In addition, respiratory protection tends to cause some sort of rashes on the face. It's uncomfortable, and therefore there's less inclination for employees to want to use it. So you put all that together, and that's why OSHA's taken the position it has on that issue. Next slide, please. So the requirements to establish a pill, which is designed to most adequately assure to the extent feasible based on best available evidence, no employee will suffer material impairment, health, or functional capacity over the 45-year working lifetime, are basically four. There's to be significant risk. OSHA initially under benzene tried to reduce exposures to benzene to the lowest feasible level, regardless of risk, and the court said, no, if there's no significant risk, you can't force an employer to reduce the exposure levels. So court said to OSHA, pick a significant risk level. A reasonable person would say 1 in 1,000 is significant, 1 in a billion is not, and left it to OSHA to decide what to choose. OSHA choose 1 in 1,000 over a working lifetime. Why? Because I believe when OSHA did its risk assessments, given the constraint that it couldn't require an infeasible measure, OSHA decided about the best it could do would be to get to 1 in 1,000. Recognizing the estimates that are used in developing these numbers always take virtually always take the conservative decision point at every point along the way. So it's quite possible that the protection level is actually better than 1 in 1,000, but in any event, that's the regulatory process. In 2017, NIOSH put out a revised cancer policy and recommended a 1 in 10,000 number, which is the one that EPA is using with respect to its ECELs. So you have to show significant risk that the proposed rule would reduce the risk significantly. The proposed measures have to be technically and economically feasible for each industrial sector affected by the rule. And then OSHA has taken the position that a rule is not feasible if it would require, I'm using general terms, widespread use of respirators. So basically the idea is most employers and most of their operations would have to be able to comply with the rule without the use of respirators most of the time. And if you can't do that, then the rule is considered infeasible. And that means OSHA sets the pill higher than 1 in 1,000 because 1 in 1,000 is considered not feasible. And then finally, the proposed measures are supposed to be the most cost-effective approach, but OSHA does not take that literally. Otherwise, you would look at it provision by provision, and it's asserted that it doesn't have to do that. So when you get to the end of it, if you try to be objective, you'd say OSHA basically lacks either the regulatory tools or the budget to set new pills. So that's why it's got 395 of them that were set back in 1970 and haven't been updated since. And then along came the Lautenberg Safety Act. Next slide, please. So if you were doing an analysis comparing a federal plan to a state plan to see whether the state plan was as effective as the federal, you would go through an analysis something like this. You'd compare the two statutes. So one thing in terms of addressing workplace safety to chemical exposures is identifying the data you need to determine whether a problem exists and how to characterize it. So is there authority under the Act to require submission of health and safety studies? Under TSCA, yes. Under the OSHA Act, no. Is there an obligation to notify an agency of a substantial risk based on new information? TSCA, yes. OSHA, generally no. Not at all with respect to animal or in vitro studies. With respect to OSHA's record-keeping rule, under the current rule, if you've got a work-related injury or illness resulting in overnight hospitalization or death, then there's an obligation within 30 days. Then there's an obligation to notify the agency. Otherwise, the agency has no information without doing an enforcement inspection to find out what chemical might have been involved that might have caused a particular incident. Does the agency have the authority to put out a rule requiring testing of chemicals? TSCA, yes. OSHA, no. Is there a requirement for OSHA or EPA to take action based on that data? TSCA, yes. OSHA, no. Not only that, unlike EPA generally, OSHA basically has no deadlines for anything. Nothing's been set in stone. The agency is totally at its discretion. And the only exception for that is every once in a while, the agency puts out a document that says, we've decided this is a significant risk, chemical risk, and we're going to address it. And then they take too long to get to it. And then Public Citizen or another organized labor group brings a successful mandamus action in the Court of Appeals, and the Court of Appeals directs OSHA to put out a proposed rule by a certain period of time and a final rule by a certain period of time. And usually agency doesn't quite make those deadlines, but it gets close. Next slide, please. Okay, with respect to a new chemical or new use, significant new use of an existing chemical, obviously, you're probably all familiar with the fact that there's a PMN required under TSCA. The OSHA Act has nothing like that. There's no notification to OSHA that any particular new chemical is being produced or distributed. OSHA would have to basically find significant risk to establish a PEL. OSHA is so overwhelmed in trying to establish PELs that it's essentially limited all of its PEL activity to situations where there's epidemiology showing cancer, and anything less than the cancer risk, other than examples like lead, rarely even gets addressed. And then even then, it's only when there's a large exposed population. So new chemical coming out is not going to get OSHA's attention. So next slide, please. Okay, the statute requires that the rule be technically and economically feasible. TSCA, no. Has to be considered, but required, no. OSHA Act, yes, for every industrial sector. And then again, widespread use of respiratory protection is not considered feasible. Can a rule ban a chemical? TSCA, yes. OSHA, no. What's the acceptable lifetime risk of a serious injury or death? TSCA, 1 in 10,000. Based on EPA's discretion and determination that was appropriate. OSHA Act, 1 in 1,000, subject to feasibility constraints. With respect to the hierarchy of controls, the typical TSCA Section 5 order talks about using the hierarchy of controls with respect to all types of exposures, which would mean inhalation and dermal. The OSHA Act only provides for a hierarchy of controls with respect to inhalation exposures. And finally, if you're looking at incentives for compliance, the civil penalty under TSCA is $43,600 per violation per day. The civil penalty under the OSHA Act is $14,000 per violation. TSCA has a 5-year statute of limitations. The OSHA Act has a 6-month statute of limitations. So when you look at the two of those, you'd say they're not equivalent in any way. Next slide, please. So what's happened so far? These are OSHA's numbers. Now remember, OSHA says that 1 in 1,000 is considered significant risk. If you look at the risk at new pill, this is from the chromium preamble to the OSHA chromium standard. You can see that OSHA's not been able to get down to 1 in 1,000 in a significant number of situations, especially the chromium standard, somewhere between 10 and 45 per thousand, according to its numbers. Next slide, please. And then in probably the most challenging rulemaking it had, because crystalline silica is so pervasively used. If you look at the pill that was set at 50 and assume lung cancer mortalities was 20 per thousand, about, and mortality from silicosis was 7 and 32 from renal disease, you end up with about 59 per thousand, or about 6% of workers projected to have a risk of fatality over a working lifetime under obviously a conservative regulatory scheme in terms of estimates, but nevertheless, that's what the numbers come out to be. Next slide, please. So EPA has developed these ECELs, existing chemical exposure limits, for 5 chemicals at least so far. So if you stack them up at the 1 in 10,000 incremental risk level, and you compare them with OSHA's, and then you do a ratio, you can see that OSHA's number is 20 times EPA's for asbestos, 333 times EPA's number for carbon tetrachloride, and it goes down the list until you get to trichloroethylene, where the EPA number is based apparently on a current assessment, and OSHA's number is based on a 1967 value, and the gap is an order of magnitude of 4 to 5. So that is the scenario that you look at when you say which agency is likely to take the lead. Another thing to keep in mind is if you look at the regulatory agenda, there's no mention of a permissible exposure limit anywhere in OSHA's agenda. It's taken, they adopted the last PEL was the silica PEL in 2016. So now 2022, and it's still dealing with a remand from the court on whether medical removal provision was required. Next slide. So with that, trying to be objective, TSCA is more proactive, covers more employees, requires a greater risk reduction. It's probably more likely to achieve compliance, and it places less emphasis on PPE. Under the Obama administration, then OSHA Administrator David Michaels wrote a letter to EPA when it was doing its risk analysis for 3 chemicals, and said that EPA was in a better position to address the issues of workplace exposures to those chemicals. And certainly nothing has changed with respect to the considerations to be taken into account on that point. So you end up with a situation where OSHA has the expertise and EPA has the regulatory authority. And I would say, in fairness, that OSHA's probably abandoned the PELS process, unless there's something unusual that comes along that's not of interest to EPA, that's of particular interest to OSHA. And silica was probably the last thing I can think of that fits into that category. So the possibility is that EPA is going to establish PELS under TSCA with OSHA's participation, and the question is whether OSHA health standards writers are actually detailed over to EPA, which would be one possibility, which would make use of their expertise on a more formal basis. And then I'm just quoting language from the inspections authority under TSCA, where it says any duly designated representative of the administrator. I believe that would permit EPA to designate OSHA compliance personnel to represent EPA in inspections. So one possibility would be to have OSHA inspectors inspecting for some of the issues covered by TSCA. May not be ideal, but at least you have people that are familiar with inspections of the workplace issues, inspecting for those issues. Anyway, that's the situation. I think next slide.
Okay.
I'll turn it back over to Herb. Thanks.
I'll take that over. Well, I think that's a remarkable statement by the OSHA administrator during the Obama administration that conceded that EPA is in a better position to handle risk associated with chemicals. And so, rather surprising statement by the OSHA administrator in my mind. TSCA is supposed to be a gap filling statute, and EPA is quite good when it comes to, addressing media concerns, air, waste, safe drinking water, things of that nature. And so, if it looks like, when it comes to chemicals, that EPA is going to take over the role of OSHA, take over the role of CPSC, the Consumer Product Safety Commission, take over the role of these other federal agencies, I'm not entirely certain that that's what Congress intended. And certainly, it seems to me that these other agencies, to the extent that they're unable to address these things, should step up to the plates. The OSHA's had, has been in the occupational exposure and health and safety area since 1976, at least, and has a lot of experience here. EPA, quite honestly, until only recently, his only experiences would have been with new chemicals. And, in terms of hierarchy of controls, if you look at consent orders and SNRs, you'll see that almost all of them have, very stringent respirator requirements. It's not uncommon for EPA to say, you have to put on a, 1,000 APF respirator. So I'm not entirely sure that there's a lot of evidence that EPA has a lot of experience in addressing occupational exposure issues. Next slide, please. That takes us up into the next issue. This has to do with significant difference between the handling by Trump-era EPA and the Biden-era EPA of the use of PPE, particular respirators and gloves, in these risk evaluations. Now, you may recall that when Trump EPA did the first 10 substances, finalized the risk evaluations, they assumed, based on evidence, that certain PPE would be used. And they can't, and then now the Biden administration, their EPA basically reopened all of those risk evaluations, deleted that assumption, and it made a huge difference in the outcome. So obviously, if you assume no PPE use at these companies, then you're going to come up with, most cases with these type of chemicals that have been prioritized for risk evaluation, you're going to come up with a finding of unreasonable risk for human health. It's already a foreclosed question. So anyway, industry groups have questioned the legality of the Biden EPA approach. Next slide, please. So what's the argument the industry is using? Well, one is I think a very good textual argument, statutory interpretation argument. They say the EPA's decision not to assume the use of PPE is inconsistent with the definition of conditions of use. Now, recall that conditions of use are defined as, quote, the circumstances under which a chemical substance is known or reasonably foreseen to be handled. And I think the argument is made, well, the use of PPE is a known and reasonably foreseen circumstance, and it's reasonable to assume that workplaces comply with the OSHA regulations, and that any other sort of interpretation would be inconsistent with what the definition of conditions of use. Next slide, please. ACC, a lot of trade associations weighed in. In fact, when we did the HBCD comments for a number of you online, we also presented these sort of arguments, but ACC has weighed in most recently on this issue. In addition to pointing out the inconsistency of EPA's approach with the definition of conditions of use, they point out that the assumption of no PPE is inconsistent with the TSCA requirements that EPA's work, their risk evaluations, be based on the best available science. And they argue that, well, if there is data showing that PPE is being used, to ignore that is not using the best available science. It's not using the best, the weight of scientific evidence. And they also say that the assumptions are inconsistent with the statutory and regulatory requirements on the OSHA Act. And they also point out that there are sort of tremendous practical problems in terms of assuming no use of PPE and only addressing PPE when you get to the risk management stage. Next slide, please. So, as is usually the case, whenever industry takes a position on something, the NGOs, here backed by unions, fired back at ACC and the other trade associations that are making these arguments. And they point out the following. They say that, well, if you look at the general duty clause under the OSHA Act, they say that's very rarely used, and it's very rarely enforced, and it's only basically used when workers are really sick or have died. I don't know if that's the argument they make. These are all quotes. They say there's no basis for assuming that OSHA's HAZCOM standard, quote, compels employers to implement the recommended controls that are listed on the safety data sheet. And I think companies that spend a lot of time, a lot of effort putting together these safety data sheets, and employers downstream that spend a lot of time and effort ensuring that their employees are appropriately handling the chemicals in accordance with these safety data sheets under their HAZCOM programs would take issue with that criticism. And additional criticism by the unions and NGOs are the quote accuracy and consistency of its safety data sheets is questionable, with studies find that 36% or more of safety data sheets and labels understate the danger to workers, end quote. I mean, again, I think a careful look at that question and those studies would be warranted. And then they say, finally, quotes, that PPE is not the panacea that industry would characterize it as. And they point out that equipment like respirators don't always fit correctly. Next slide, please. So I think the main point that NGOs are trying to make is that one shouldn't rely on PPE at all. Really, you should rely on PPE as a last resort. That really where you should focus in is elimination of these chemicals, whole stop, substitution of these chemicals with other, I guess, less hazardous chemicals, or if that is not possible, or at least for until substitution becomes available, to employ engineering controls. And that is the hierarchy that the NGOs are looking for. And obviously the OSHA approach would be inconsistent with that hierarchy. The assumption of lawful PPE use would be inconsistent of the goal of eliminating these chemicals. And so that's why the NGOs and are championing what the Biden EPA is doing. But that said, if you listen to Larry's presentation, I think, quite frankly, that that OSHA should be stepping up. I mean, they've been entrusted by Congress to protect the health and safety of workers. And to the extent that they're not carrying out their mission, I think they should step up. And quite honestly, this question of resources, EPA doesn't have any resources either. I mean, right now they can't seem to review any PMNs that are submitted to them. And so, there's no indication that they're going to get a lot more resources to basically take over the mission of all these various federal agencies. So it's not quite clear what's going to happen. Next slide, please. Well, those are my final thoughts, which segues with the amount of time. Larry, do you have a final thought?
No, I think you captured them well. There's
Okay.
a problem, to say the least. I think that if I didn't mention that there were many efforts at OSHA Act reform that went nowhere. Mm-hmm. And it appears that the NGOs and the organized labor found a different path to take to get indirect OSHA Act reform.
Yeah, that sounds like it. That looks like it. Yeah, that does look like it. But quite frankly, EPA has a limited amount of chemicals they're going to be able to deal with. I mean, the Lautenberg Act was promulgated in 6 years ago, and they haven't even finished the first 10. So this, I mean, again, I'm not really sure what the ultimate end game is by the NGOs. But in any event. By the way, the question, I have a question in my mind is how EPA is going to inspect the workplaces for CEL or ECEL compliance. I mean, EPA's traditionally, their traditional experience is to inspect manufacturers of chemicals. They have very little experience, at least in the TSCA office, inspecting downstream users. So, there's a huge number of these facilities. I mean, I doubt even with the states, they would have enough enforcement authority. You suggest that perhaps they'll use the OSHA inspectors. That remains to be seen. Anyway, I have to go because we have a REACH thing in 1 minute. So thank you, everybody. Please, the REACH program is in 1 minute, and it's a very, very interesting one. So please stay on, and I think you need to sign up separately. You have a link, but it's a very, very interesting one. It has to do with one substance, one evaluation, which is a proposal in Europe. Basically, that if the European Chemical Agency does an assessment of a chemical, then all the other agencies like the European Food Safety Administration, we adhere to that first evaluation. All right, take care, everyone, and bye. And I'm Larry. I'm joined by Larry today. Did a great job. Bye. Bye, everybody.
Thank you. Bye.
Bye.